Hello, my name is Robert Larson. I'm the owner of the Larson Law Office with offices in Mesa and Queen Creek, Arizona. And today I'm going to talk about a resolution management conference, what it is, how to prepare, how to get the most out of it. So the resolution management conference is typically the first court hearing that you would have in family court. Whether someone's filed for divorce or a custody case or going back to court to modify court orders, usually the first hearing is a resolution management conference, and I'll just refer to it as an RMC at this point because that's what judges and attorneys call it, and it's much shorter. But typically the RMC is about 15 or 30 minutes long, and the reason why it's a short hearing is because it's not an evidentiary hearing. So that means you're not going to present evidence, you're not going to give testimony at that hearing, and that's frustrating for a lot of people. I've seen so many people get into this hearing, especially it's their first time to get in front of the judge, and there's so many things they want to say, and they start trying to tell the judge everything they want the judge to hear, and the judge interrupts them and says, "We're not here for that today. We're here to basically do some other things that I'll talk about in a moment." And so people find that frustrating. So the first thing you should know is it's not a trial, it's not an evidentiary hearing, so you're not going to get a chance to testify, and you're not going to present evidence and things like that. And because of that, the judge can only do two types of orders at this hearing because you're not presenting evidence. One is the judge can take anything that the two parties agree on and turn those into court orders because you're doing it by agreement. The second thing is the judge can issue orders that are related to scheduling and deadlines and things of that nature. So there's a few things that you should do before the resolution management conference to make it more productive. And so usually when it gets scheduled, it's going to be 1 or 2 months away, sometimes up to 3 months. And so you have to wait a little while, but that's by reason, there's a reason for that. It's not just because of the court's calendar, although it is partially because of that, but it's also because the judge hopes that you'll be doing certain things in the meantime so that you're more prepared and so that you've advanced your case to a certain point by the time you get in front of the judge. So the judge will be disappointed if you get in to the hearing and the judge finds out that neither side has done anything since the hearing was scheduled. So what should you be doing? First, you should be collecting whatever relevant evidence you have and disclosing it to the other party. That means providing copies of relevant information to the other side. What witnesses you intend to use if this case goes to a trial, what documents you have or other types of evidence that you have that you would use if you went to court. And so you should disclose those to the other party, and the other party should be doing that to you as well. And by exchanging information, both sides are in a better position to evaluate their situation and make decisions going forward. The second thing that should happen is both sides should talk before you go into court. The first question the judge will ask you when you start an RMC is, have the two sides talk to each other, and do you have any agreements? So that the order to appear for the RMC will usually say that. It will usually say you are ordered to have a meeting before the hearing, whether it's in person or by phone or whatever. Usually both sides need to meet ahead of time, and sometimes it only takes a few minutes. Sometimes the two sides are really far apart and have opposite opinions of what should happen, and but the judge will still be happy to hear that the two of you have talked and that you can report to the judge that, yeah, we talked and we don't have any agreements, we're very far apart. At least then the judge knows that for sure. If you haven't talked, then the judge is going to be a little frustrated because you never know if it's possible that something could have been worked out. And if you have attorneys, usually the attorneys are just going to do the conversation as opposed to the parties to the case. If you do have any agreements, the judge will take those agreements and, like I mentioned, turn those into court orders. And those could be agreements on final outcomes. And sometimes we can resolve an entire case at the RMC. It doesn't happen too often, but it has happened, and judges are usually very happy to see that. But you can also have agreements on temporary issues. So maybe you don't agree on a final outcome, but you agree on a temporary basis until we get to a final court order. We're going to follow certain temporary arrangements, whether it's child support or parenting schedules, or who's going to live in the home, or whatever it may be. You can come up with temporary orders that will remain in place until your case is completed. It could just be agreements on procedures. So maybe you don't agree on any substantive issues, but you agree that there should be a 60-day deadline to exchange information and try to negotiate outside of court. Or it could be an agreement that an expert needs to be appointed on the case, or maybe there's an agreement that there should be drug testing of one or both of the parties, or things of that nature. So the judge will take whatever agreements you have and make those court orders. Another one I should mention that's a big one, sometimes the parties will agree that they should have mediation, and the judge will schedule that as well. So the judge can order things that you've agreed on, and the judge can also issue orders on procedures and deadlines. If someone's accusing someone else of substance abuse or domestic violence, the judge could order someone to do drug testing or an assessment for domestic violence, and things of that nature. So the judge can appoint experts who may be used in a case and things of that nature, but the judge can't issue final orders because you're not presenting evidence, like I said at the beginning. So the keys are, you want to disclose what information you have at the time. You want to speak with the other side ahead of time. Sometimes you actually have to serve the order to appear for the RMC. So if that's the case, you definitely want to get that service done as fast as possible. Otherwise, your hearing is going to be continued to another date and possibly canceled eventually if you don't get the other party served, because you can't move forward if they don't know about it. Usually, there's 1 week before the hearing, you're supposed to submit what's called a resolution statement. It's basically a summary of what you want to happen in your case. It's a list of the issues that are relevant to your case and the outcome that you're asking for. You're not supposed to argue your case, although sometimes people do, and sometimes even attorneys do. But you're not supposed to argue it. You're just supposed to give the judge a summary so that the judge can look at it in like 1 or 2 minutes and see what your position is on the issues and see how close the two sides are on different issues. So there's a lot of work that's supposed to be done before the RMC. If we do those things ahead of time, it moves your case forward so much quicker. If you just show up to the hearing and you tell the judge, here we are, and we haven't done anything, the judge will probably give you another 60 days to do the things that you could have done already while you're waiting for the first hearing. And so you're kind of just wasting time if you do that. That's not the end of the world, but you can just move your case along so much quicker and accomplish so much more if you get these things done ahead of time so that your RMC is more productive. Once the RMC is done, you'll get some orders on whatever orders were issued. You'll get a minute entry that shows a summary of that, and you usually have a deadline that basically, they call it a dismissal deadline. It's usually at least a couple of months out, and whatever's scheduled after the RMC, the judge will give you that deadline so that you have to report back to the court by a certain date. By that dismissal deadline, you have to tell the judge, you have to file something to let the judge know where things are going at that point. But that's not really our purpose here today, but that's what happens when you get done with the RMC. So if you have any questions about what a resolution management conference is, feel free to contact my office. We'll be happy to help. And if you like the video and think it's helpful, please like and subscribe so that you can get more. And let me know if you have any questions. I'll be happy to respond.